Well, thank you for the invitation, and it's awesome to see so many people here to talk about IP. I feel like I'm always the IP nerd in the room, so we're in good company. So I'm gonna tell you a little bit about kind of a collection of work that has been developing over the years. It also builds on other work that is currently out there that I'm calling intellectual property restitution. And just to give you an idea of what we're talking about when I say the phrase intellectual property restitution, I don't mean I'm giving someone the copyright in a work that maybe they made and then assigned to me and we're giving it back, right? Like, because you can assign a copyright, right? We're talking about a bigger, much broader question of what happens when someone is dispossessed of their cultural heritage through colonial or imperial conquests. That item goes back to a country and begins to build an incredible amount of wealth for that country, related to visitors at the museum, local economies, the digitization of all of those objects, the copyright in those digitizations, the way that you can license those things to individuals, even deny requests to use the images for publications, for research, for all sorts of things, right? So we're talking about what we would call in intellectual property derivative works. So these are works that are created around a source object, and in this case, we can fill in the blank for any source object. But it's all of the derivative works that are produced around an item from the moment of its dispossession. We live in an information society, a global political economy. All of this is creating, especially with AI, incredible value for countries who have hoarded these heritage assets and built a lot of wealth over the years around them. Okay, so this is we're starting hard, okay? This is what I mean by intellectual property restitution. And it's actually work that I've been doing with museums. Okay, so museums, people within institutions, people are very interested in trying to think about how do we create more equitable frameworks for access, for the return of epistemic assets, anywhere from the metadata to the legal documents to everything that's necessary to be able to write about a given history of an item and correct the record, right? So this is where we're starting. I have a paper that's hopefully coming out by the end of the year. That's called intellectual property restitution. But I'm gonna do a little bit of scaffolding because I'm assuming that you all do not have like maybe tons of IP knowledge or even knowledge about these bigger issues of restitution, right? And this question of who should be carrying or controlling or holding a lot of assets that relate to multiple organizations and groups and communities and individuals has really surfaced and received a lot of attention in the past few years for a number of reasons. One, we're learning that this kind of narrative of institutions are best placed to care is not necessarily the truth, right? What do we mean by that? Who should have access to generate knowledge? What is knowledge, right? Why are we so object-focused rather than culturally and people-focused when it comes to thinking about what we're trying to preserve? If you don't know this reference, I should probably explain what's on the slide. There was a curator at the British Museum who was found to have sold off thousands of items on eBay, or hundreds maybe, because they had not been cataloged by the British Museum. And you don't know if something is in a collection unless it's part of the catalog. And if it's not in the catalog, then it doesn't exist. So we have a couple of issues there. One is, if you're trying to find your heritage and ask for it back, and it's not been cataloged in a museum, it does not exist in the sense of you being able to locate it and make that request, to file that claim. But numbers that came out were less than half of the British Museum's collection is actually part of the catalog. Let's distribute those items, right? If we don't have time to catalog them, we don't have time to study them, we don't even know that do you see what I'm saying? So there's a lot of epistemic justice issues that are connected with this that also relate to all of the things that we want to be doing around cultural heritage and these items. Another thing that really brought a lot of attention to this was the Savoie report, which came out in 2018 in France. It was a report that was commissioned to really look at the question of what is France's obligation to African countries with respect to restitution. And the writers of this report estimated that something like 90% of African cultural heritage actually resides outside of Africa because of the immense looting that happened over the 18th to 19th century and even before, right? So one of the things that this did was create a lot of movement with respect to people who have been asking for their heritage back for a really long time, but this publicly applied a pressure in a way that gave a lot of people the arguments that were necessary to get actual national reform started. And this is also kind of the origin story for where I started to think about this, because the report is amazing. You should go read it. It's beautifully written. And then there's one tiny section that talks about digital content, okay? And in here, it makes some recommendations that on their face sound totally legit. So it says we should think about sharing all of the digital collections. We should create a single open access portal to documentation, which is important for all the reasons that I started out saying. You gotta know where your stuff is in order to make the claims to get it back. But we also have some recommendations around a radical practice of sharing, of rethinking image rights, which I am hardcore here for. But if we're doing it from an approach of systematically digitizing everything, as a lawyer, I'm always going to be the person to go, oh my God, wait, I'm so sorry. I'm here to rain on your parade because we need to think this through. So where something is physically digitized, all of the laws of that country will attach to the asset, who the rights holder is, what sort of contracts can be signed around it, right? So those very valid questions of land, of jurisdiction, of borders, and even related to colonization apply then to the digital asset. But to then say, okay, well, let's get rid of those. Let's say that there's no copyright in any of these images so anyone can use them for any purpose. Well, you're actually now exposing those materials to additional wealth and knowledge extraction because anyone can use them for any purpose, including AI. And we have a lot of power differentials in the world that exist when it comes to who can store the images, who can run the types of programs that we want to see on those images. So if we want it to be a more equitable system, we need to even think about some of those really specific open access questions as really being part of what should we be doing when we think about restitution and how to design it more equitably. So something to kind of position this in the UK. You know, our copyright law in the UK, which is one of the first copyright laws that, moved on from this idea of having a monopoly that was just a privilege to you actually have to contribute something towards learning, comes from the Statute of Anne in 1710. It is a colonial invention, right? And it was actually transplanted through bilateral and multilateral treaties, as well as conquering land and having something called crown copyright, where you are doing work that now gets owned by the crown. So we have a long history of copyright. When it initially started, it only protected things that were reproducible, so books, right, and authors. About 1735, we have something come along that's called, do you love this? This is meta. This is a document that was never protected by copyright, but at the bottom we've got copyright trustees of the British Museum, right? So we have some initiatives that essentially say, all right, we're going to now extend copyright from books to other things that are reproducible, and one of the first things that is the engraving. And William Hogarth, if you're into engravings or you're into copyright history or any of this prints, even social commentary of the time, he was really upset because his prints were getting ripped off. They were being copied because there was no protection, and the things that he would produce and then other print sellers would come in and grab and then literally copy and then sell at a cheaper rate. So he lobbied with a few other people to Parliament to get copyright extended to engravings, okay? At the time that copyright was introduced, it protected the engraving for 14 years. So we should also think about, well, what does copyright look like today? Today, the term of protection is tied to the lifetime of the author. So me, let's say I die in, I don't know, 2180, right? Is that reasonable? Let's not make this. And my copyright in all of my works doesn't expire until 70 years later. Okay, so what is that, 2150? So my works pass into the public domain in 2150. That's a long time. So we went from 14 years to lifetime of the author, and then we also have the very country in which Hogarth made copyright a thing for visual artworks. It's collected by a museum that claims copyright in an image that is not protected by copyright. Your work has to be an original expression in order for copyright to attach to it. But there's nothing we can do if the people who hold the asset say there's copyright and it's ours, right? There's nothing we can do. So a little bit of irony here. It's kind of fun to tease that out. When we go here, it's not so fun anymore, okay? This is someone's ancestor, Ho'ohakananaya of the Rapa Nui. And when we apply literally a claim to the image that says this is mine and I can commercialize it, we have that additional layer to consider that plays into the very things that we're thinking about when we're building epistemic assets, we're building digital collections. This is now a 3D scan, right? We have multiple different formats that exist. And Ho'ohakananaya has been requested for years by his descendants. If you go to the actual British Museum, he's just plopped in the middle of tons of other things. And when you walk up to the actual title card, you'll see that there's some signaling, right? Basalt statue known as Ho'ohakananaya, probably stolen or hidden friend. But here we also have validating language that indicates this was a gift donated by Her Majesty Queen Victoria, photo, trustees of the Brit. So there's layers upon layers of control and locking it down because there is an assumption, right, that the legal frameworks support this behavior, but there's also an assumption that it can produce commercial income because of what we're told about intellectual property. So we do have legal measures that think about how we need to start kind of organizing ourselves around this. They are not binding in most countries. So one example is the UN Declaration on the Rights of Indigenous Peoples, which uses the term cultural manifestation, rather than object, asset, image, like these sorts of things, which is pretty broad. And we also have language that acknowledges the right to the intellectual control of, and lots of other things that should be happening around the way that we engage with these items. But when you go and you see how this is then, interpreted in practice, for example, the Musée Quai Branly has over 1 million objects if you search for Africa, right? Or even something as more specific like Benin. And the Sarr-Savoy report, itself doesn't say like, well, let's empty museums, let's return everything, right? But it does start by identifying specific things that absolutely should go back. And so the Benin bronzes were one of those, and you may be familiar with a lot of other countries that have kind of started organizing around the Benin bronzes for that reason. But we've got the images, right? Even the exhibition photos, how it has historically been exhibited and described. We have contemporary forms of exhibition like this page. It's been merchandised through postcards, right, where we're thinking about all of this in terms of intellectual property. And we also want to think about who's been benefiting economically even from the copyright itself, right? Does that become part of the restitution process and even should be subject to reparation? It's been redocumented under new technologies. We have exhibition catalogs, authority, knowledge generation, dissemination, metadata, item data, and even images of ancestors presenting them as exclusive intellectual property. So it's not just the source object that we need to be thinking about, right? This is also where I'm going when we're talking about intellectual property restitution. It's the ability to access these items and write your own stories about your own culture. And this is really, what the issue is. Because when we apply rigid legal concepts and even rigid understandings of property, we start to see how they compound in different layers. So when the British Museum announced their new collections website, some of the terminology around the word mummy, it had in museum studies switched to using human mummy, right, to also stop the dehumanization and objectification of individuals. But they published it all. So this image is no longer available, but what it was a woman who was described as being excavated from a cave in Peru, who was there with 12 other people who were trying to escape the Spaniards and then died. Okay, it's donated by, right? So we're also thinking about the structures of the data, the descriptors, and the way that it's framed. These things are embedded in so many things that we do, and the ability to even redescribe that can have structural changes in how the rest of us experience some of these things. So, if our heritage institutions are setting, these kind of general standards for the public and the rest of us and how we think about it, which is how they want to position themselves, one of the questions that we should think about is, should we be digitizing and commercializing things that may be referred to as people's souls, right? Go back to the example of the Moai. It's in everybody's phone, right? And some of the arguments that you will hear against restitution or even digital restitution often relate to, well, preservation, right? These two are rigid concepts about what it means to preserve an object. So there's a great reference from Hamamadi Bokwam, who's the director of Dakar's Museum of Black Civilizations. And what he basically says is, it is also preservation to take an item that is sacred and should be buried in a forest and to do that once it's returned. And it's our prerogative, right? So it's that attitude that we're also bringing, to the idea of what intellectual property restitution should be. And there is a lot of stuff that is going on at the moment around this, and even formalizing in national government. So you'll hear different terminology in Australia and New Zealand. We'll hear indigenous cultural and intellectual property rights. Okay, so it's called ICIP. Also indigenous data sovereignty, we have some formalized adoptions of that. One is because Australia is now bringing in legislation around this. The other is because, of course, in Aotearoa, New Zealand, there's a bicultural government, right? It's a constitutional requirement to have these sorts of things in there. In the US, we have some updates to the Native American Graves and Repatriation Act, which start to think about questions of display. What does display mean? And you have to get free, prior, and informed consent to display anything that's associated with a federally recognized tribe. So one of the questions that we're looking at is, well, how does that apply to digital, right? Some institutions took down digital assets. Some were like, no, these are entirely separate. But then we also have Canada, which is implementing UNDRIP, right? So this is the UN Declaration on the Rights of Indigenous Peoples. And it's also being integrated into the Canadian Museums Association and starting to really shift and change how people are approaching these things. Why we're focusing on this really hard line of intellectual property restitution is because all of these jurisdictions share a very specific relationship. We have settler colonization, right? People who are living in the same jurisdictional boundaries, who are thinking within a singular framework about how to negotiate these issues. Europe doesn't have that, right? We have a completely different dynamic. We can call it post-colonial, right? Because are we really post-colonial? But we have post-colonial studies and things to think about. From a legal perspective, we have a cross-border issue, but we also have diaspora stakeholders in the country, right? So we need to be thinking about all of those things a little bit differently. So, why? What? How? We're arguing that intellectual property restitution is the lens, rather than cultural property restitution. We need to go to intellectual property restitution because it actually then picks up on the source item, but it captures everything that a country would say is our intellectual property or is separate from, right? These are the derivative works, and it could be all kinds of things, right? Because if we're not thinking about that as being part of the lifetime of the work and the impact of the dispossession, then we're not approaching restitution from a full and complete understanding of what it means to try to remedy these past wrongs. And so thinking about how we do that, another big difference is all of the cultural property is kind of locked up in these political conversations, right? Like, how do we change the British Museum Act of 1963 to allow people to de-acquisition? This is all private law. We're talking about archival materials, images, copyright, right? Property rights, things that are not defined as part of the collection that needs to be accessioned by public law. So private law can actually step in and give us a lot of flexibility. And one of the reasons that we want to think about this maybe you've heard of Open GLAM, right? Galleries, libraries, archives, and museums, is because this is another movement that's also taking off at the moment, and it's not thinking about restitution, okay? So we've all been making arguments for a while that institutions should stop claiming copyright in things that they don't have copyright in. They should make the beautiful paintings, all of the stuff that they have digitized, available to the public because it's part of their mission. But we should all be able to use those things once copyright expires. And there are more and more institutions that are kind of joining this movement and releasing anywhere from 1 image to 5 million without a copyright or under conditions that allow you to use it. So you can go to this website, you can probably even Google it, Open GLAM Survey, where we start to document all of the institutions. And it's really important to do this because while we have over 1,700 and more than 100 million assets that are available, it's less than 1% of cultural institutions globally. But when you actually map where the activity is happening, right? We have a lot of institutions that are releasing data and descriptions and images under ways that allow it to all be like ingested and made into new products and artificial intelligence and all of this, where it's primarily in English, right? Or other European languages, according to those data systems and structures. And it's essentially a global minority that's defining a digital landscape for a global majority, okay? And so starting to think about how we also shift that can have some huge impacts on the day-to-day tools that we start to see get uploaded into our phones without our permission, right? In ways that you're like, wow, I didn't understand that this was also relevant to restitution. Absolutely. And because maybe you've also heard about how institutions are getting hacked. British Library, right? Was it last year? Oh man.
2013, and they still haven't restored it.
Well, because there was also one in like either 2023 or 2024 as well.
That's right, at 2023.
Okay, yeah. So basically, they just had to take their servers offline, and they can't even plug them back in. They didn't have some of the data backed up. They wanted something like, this is the thing where I was like, who was this? The people who were holding the data ransom wanted something like 600,000 in Bitcoin, and I was like, that's it? But this has been happening more and more as well. It's not just the British Library, it's the Met Opera in New York, it's the entire Royal Museums Nationale in France that manages all the collections of the Royal Museums. We also had the Museum of Natural History in Berlin. So we're starting to see actually these assets become kind of proxy for what people see as being hackable, going in, trying to like extract more wealth. So some of those questions where we say, well, what is preservation and who should be best, kept to make sure that it's all preserved for everyone, also apply to the digital questions that we're seeing as well. So this is why digitization is not neutral, right? You're creating a new asset with a new author, sometimes without considering the underlying artists or people who made these things, and then presenting it as an asset that often is talking about how the institution is doing something wonderful, but is not considering the digital aspects. And it's also why open access is not neutral, because when you publish something open access, not only do you kind of remove the care and autonomy around an asset that really should be kind of restored. There's a wonderful paper that's called The Crying Child in the Archive by Timi Odomosu, where she talks about what it means to start excavating these images and creating systems of care around them to really restore the humanity to the individuals who were dehumanized during their lifetime. And why it's really important to start with the act of dispossession, right? So this is the military campaign on Benin. This is everyone sitting around with the booty, right? All stacked up. And these images are also really important for telling that story, but we really need to go straight to the heart. So focusing from the object to epistemic justice, of course, is interesting when you're thinking about how do we interpret legal measures, because you're never going to see digital in half of these, right? But we obviously know that digital is now completely integrated into what institutions are doing, right? And there may be approaches where people are thinking, well, digital helps us do our main mission, but it's almost not the case anymore that you can be an institution, unless you have obviously financial limitations, without engaging in some way in digital. So it's something that needs to be considered from the outset. And again, I mentioned flexibilities in private law, but one of the ways, that we're thinking about this is if you are withdrawing entirely as your starting point, then that puts the community of origin or the claimant in a position where they're setting the terms of what restitution means and what it means to them. So we've been working with some institutions around this in terms of trying to structure it according to these stages for new relational ethics. And this actually comes from the SAR-Savoy report and what they argue needs to happen around the items themselves, this new relational ethics. But starting with transparency to make sure that all of that information is known, to then thinking about this reversal of power inequities, to then transferring everything possible, right? And sometimes it may not be possible to transfer things because the law says not, but you don't have to enforce the rights that the law says that you have, right? So you can come up with agreements about what it means to not enforce those rights in a way that also informs the people who are receiving and then caring for the items of any sorts of those things that can't be waived, but they need to be aware of, right? Thinking about reparations, also relating to what financial contributions might be appropriate if you've been building wealth off of the licensing of the images, and post-custodial knowledges being the end, or post-custodial models being the end goal. So thinking about these as like knowledge transfers that are really shaping stewardship, but thinking about the integration of digital in every aspect of what we're doing, even down to hosting, data and metadata development, and how we start to think about who is excluded, but that also being okay to rebalance what those inequities have historically looked like. We do have some institutions that are doing some really cool stuff. So first and foremost, the German Digital Library is taking all of the work that's been happening for a while in digital and pulling it into an aggregator, which is meant to be a single source where people can start searching for things. What's interesting is it needs to be labeled accurately in order for you to be able to find the thing that you're looking for. But we are also seeing work where people are developing image recognition models. So you can essentially submit images as part of the search because the data itself may not be reliable. If you go to the Met's collection, they've also been very, very high in the news. Maybe you saw one of their big restitution cases because Kim Kardashian took a picture of an Egyptian sarcophagus at the Met Gala and posted it, and someone was like, that shouldn't be there, and now it's not. But there's been a lot of this going on, and partly because there was a trader who was connected with someone dubious in Cambodia. Someone knew that people who were on the board at the Met collected through that trader and had made donations to the Met Museum. And because they had digitized everything, that journalist just started using their search engine to locate all of those things. So it's great for transparency, right? And now when you go to the Met Museum, they have a CC0, right? So this is a policy that says we are not claiming rights in any of the stuff that we're digitizing. But for images that have been returned, you cannot download it. It says image not available, and the actual item page says this item has been returned to the country of origin. So this brings us back to law and what is law supposed to do, especially if we don't have specific laws on these things. We can always read in the outcomes that we want to see, especially if things are phrased in a way where we think about shared stewardship. What should that actually encompass? What does it mean to have an ethical return? And the Smithsonian has been trying to do this and also construct policies that are a little bit more forward-looking in terms of how they can adapt without having to be revised. But this is essentially the direction, that all of this is going. So I've included, here we go, Crying Child, Temioda Mosu. This is another really great paper. This is the end, but these are, if you're interested in this, these are some very wonderful papers that you can kind of dig into to think about some of these issues a little bit more closely. So there we go, the end. Thank you.